"You don't belong in this room." He said it the way people say things they believe are obvious. Not cruel, just certain. The way a man tells a child the pool is closed, or a waiter tells you they're out of the special, matter of fact, final. Miriam Caldwell didn't sit down. She stood at the edge of the conference table in her beige cardigan and her reading glasses on a chain, and her orthopedic shoes that her daughter had ordered online, because Miriam's left knee had never been right since 2019. She held a manila folder against her chest, like a hymnal. And she looked at the man who had just spoken. 31 years old, tailored suit. A law degree on the wall behind him that caught the light. And she did not move. "My grandson's name is on this deed," she said. "I think I belong here just fine." The man's name was Carter Whitfield, junior partner at Whitfield & Crane, LLP, downtown Nashville. His father had built the firm. Carter had inherited the marble floors, the brass nameplate, the particular posture of a man who had never once in his life walked into a room and wondered if he was allowed to be there. He looked at Miriam the way people look at a notice on a parking meter. Annoyed. "Already dismissed." "Ma'am," he said, and the word had a weight to it that wasn't respectful. "Your grandson is 19 years old. He has no legal standing in this dispute without proper representation. If you've come here without an attorney, I'm going to have to ask you to reschedule." "I didn't come without one," Miriam said. Carter blinked. He looked toward the door. No one else had come in. "I am one," Miriam said. The room went very quiet. Miriam Caldwell lived on the east side of Nashville in a neighborhood that used to have a different name before the developers arrived and started calling it things like the Emerging Corridor and the Urban Revitalization District. The house she lived in had belonged to her husband Edmund for 36 years. Edmund had painted the shutters blue himself. He had planted the magnolia in the front yard that now scraped the power lines. He had died in that house 4 years ago on a Tuesday morning, quietly, the way he did most things, with Miriam's hand in his. She was 64, 5'2", silver-haired. She moved carefully because of the knee. She wore the same 3 pairs of shoes in rotation. She kept her garden the way Edmund had taught her, and read 2 books a week, and made biscuits from scratch every Sunday morning for whoever showed up. If you saw her at the grocery store, you would hold the door for her. You would not ask her what she did for a living. That was understandable. Most people who knew her now didn't know what she used to do. Miriam Agnes Caldwell, née Harper, had passed the Tennessee bar examination on her first attempt in 1985. She had spent 22 years as a trial attorney, first at a civil rights firm, then as a solo practitioner who took cases other lawyers wouldn't touch. She had argued before the Sixth Circuit twice. She had never lost a custody case. She had represented 43 families in wrongful eviction proceedings and won 39 of them. She had retired in 2008 when Edmund got sick the first time. Not because she had to, because she chose to. Because some things matter more than billable hours, and she had always understood that clearly. She folded her bar card into a cedar box on the closet shelf, and she didn't open it again. She raised vegetables. She read. She drove her daughter Constance to doctor's appointments. She walked her grandson Marcus to the bus stop, even though he was 19 now, and told her he was too old for that. She was ordinary. She intended to stay that way, until the letter came. Marcus had been living in the house with Miriam since his mother moved away. Constance had married a man named Derek 2 years ago and followed him to Denver. It was fine. Miriam understood, but Marcus had 1 semester left at Nashville Community College and didn't want to transfer, so he stayed. He was a quiet boy, thoughtful. He wanted to be an architect. He drew plans in his notebook the way other kids doodled, careful, precise lines, rooms that made sense, houses that fit the people who lived in them. He had saved money since he was 16. Every paycheck from the grocery store, every birthday card with a 20 in it, every summer he worked 2 jobs instead of 1. When Edmund died, there was a small inheritance. Not much. But Edmund had believed in Marcus the way he believed in the magnolia. Plant it, water it, don't crowd it, and one day it'll be taller than you expected. Marcus found a property. A lot on the east side, 3 blocks from Miriam's house. Affordable. Not pretty, but in a neighborhood he knew, near people he cared about. He wanted to build something. Maybe a duplex. Live in one side, rent the other. He came to Miriam with the listing on his phone, the way he used to come to her with his drawings. "Grandma, what do you think?" She looked at it carefully. She asked him questions. She told him to sleep on it 3 nights before he decided. He slept on it 4. Then he made an offer. The seller accepted. And somehow in the weeks that followed, the transaction that should have been simple became something else entirely. The lot, it turned out, had a contested title, a claim filed in 2021 by a holding company called Whitfield Property Solutions, LLC. The same Whitfield as the law firm. Carter Whitfield had represented his own family's company in a quiet title action 2 years earlier. He'd won by default because nobody showed up to contest it. Nobody had told Marcus. Nobody had told anyone. Marcus came home one evening with his face like concrete. He didn't cry. He didn't yell. He set his bag down in the hallway and sat on the couch and stared at a spot on the wall for a long time. "They're saying the lot isn't mine," he finally said. "That the title never transferred right. That some company owns it and I just paid for something they claim was never for sale." Miriam set down the book she was reading. "Tell me everything," she said. She didn't sleep that night. Not because she was worried. Because she was reading. She went into the closet and got the cedar box. She opened it and looked at the bar card for a moment, and then she opened her laptop and spent 6 hours going through public records, title histories, the 2021 quiet title filing, and every case Whitfield and Crane had touched in Davidson County since 2018. By 4 a.m. she had what she needed. By 7 a.m. she had called the Tennessee bar and confirmed her license was still active. She had maintained her CLE credits, quietly, every year, the way she maintained the garden. Some things you keep up even when you're not sure why. At 9 a.m. she called Whitfield and Crane and requested a meeting. The receptionist asked who was calling. "Miriam Caldwell," she said. "I represent Marcus Caldwell in the matter of the contested property at 1418 Shelby Avenue." A pause. "And what firm are you with, Miss Caldwell?" "Caldwell Law," she said. It wasn't a lie. It was just a name that hadn't been spoken in 16 years. Carter Whitfield had prepared for this meeting the way he prepared for everything, by assuming it would be easy. He had the title documents. He had the 2021 ruling. He had 3 associates who could pull case law in under an hour. He had the confidence of a man whose name was on the building. He had not prepared for Miriam. When she walked in, cardigan, glasses on a chain, orthopedic shoes, manila folder, he made his assessment in under 4 seconds. He had a type he expected to see across the table from him. Miriam did not match it. "You don't belong in this room," he said, and meant it to end the conversation before it started. It didn't end. "I am one," she said. 2 of his associates exchanged a glance. Carter kept his face neutral. "Your bar number," he said. She opened the manila folder and set a single sheet of paper on the table. Her bar card, her license status, her active registration. Clean, current. Carter picked it up. "Read it." Something shifted in his face. Not much. But enough. "All right," he said carefully. "Mrs. Caldwell, what is it you believe your client has a claim to?" And Miriam Caldwell, who had not stood before opposing counsel in 16 years, opened her folder and began. She was methodical. She did not raise her voice. She did not perform outrage. She walked Carter through the title chain, the way a teacher walks a student through long division, step by step, no shortcuts, no assumption that they were keeping up. The original seller had conveyed the property in 2020. The deed had been recorded. Marcus had purchased from the estate of that seller, a legitimate transaction, documented, witnessed, notarized. The 2021 quiet title action Whitfield Property Solutions had filed came after the deed had already been recorded in the county register. "Your client's action," Miriam said, "was filed against a property that had already changed hands. The notice was not served to the subsequent purchaser. The ruling was obtained by default because the person who should have been notified, the rightful owner, was never informed the action existed. She set 3 documents on the table: the 2020 deed, the county recording timestamp, the service list from the 2021 action. Marcus's name was not on the service list. Carter stared at the documents. One of his associates, a young woman named Beck, leaned in and looked, then leaned back, then looked again. The recording date, Beth said quietly, not to Miriam, to Carter. Carter said nothing. The property transferred before your client filed, Miriam said. The ruling is void. The title belongs to my grandson. And if Whitfield Property Solutions attempts to enforce it, I will be filing for sanctions and moving to vacate the judgment in the morning. The room was quiet in a particular way, the kind of quiet where everyone in it is doing math and getting the same answer, and nobody wants to be the first to say it out loud. Carter Whitfield set the documents down. He straightened the edge of his notepad against the table with one careful motion. I'll need to consult with my clients, he said. Of course, Miriam said. She stood, she collected her folder. She put on her coat. I'll expect a response by close of business Thursday. After that I file. She walked out. She did not look back. Beth found her in the elevator lobby. Miss Buse Caldwell. She was young, maybe 27, carrying a legal pad against her chest. She glanced back toward the conference room, then at Miriam. I wanted to say, I reviewed that title chain last month. I flagged the service issue to the partners. I was told it wasn't material. Miriam looked at her. You put it in writing? Miriam asked. Beth nodded. Keep a copy, Miriam said. Somewhere that isn't their server. The elevator opened. Miriam stepped in. The doors closed. There are moments that hinge on a small, quiet thing, a sheet of paper, a timestamp, a young associate who wrote a memo that her supervisors buried. That memo became the center of everything. What happened next did not happen slowly. Carter Whitfield called his clients, his father, the silent partner behind Whitfield Property Solutions, and the conversation that followed lasted 11 minutes. Nobody knew what was said. But at 4:47 p.m. on Wednesday, one day before Miriam's deadline, Carter's office called Marcus's cell phone with an offer to settle. Marcus called Miriam. They want to pay me back the purchase price plus fees, he said, and they'll drop the title claim. Miriam was quiet for a moment. That's not enough, she said. Grandma, that's everything I paid. It's not enough, she said again. They ran a fraudulent title action against a property they had no right to claim, and they profited from the confusion it caused for 2 years. There are other buyers out there who got different letters, Marcus. Other lots, other families. She let that sit. Call them back, she said. Tell them we'll settle when they provide a full accounting of every property. Whitfield Property Solutions has claimed through quiet title action since 2019. Everyone. A long silence. Is that even possible? Marcus asked. It's possible, she said. Whether they'll agree is something else. But let's ask. They didn't agree. Not at first. Carter Whitfield had never had anyone push back this hard on something his firm considered settled. His clients were not accustomed to being the ones who had to explain themselves. They were accustomed to being the ones who asked for explanations. There was a certain vertigo in it. He came back with a counter. Miriam declined it. He came back again. She set the filing papers on her kitchen table, sorted them into order, and told Marcus to plan for a long week. Then Beth's memo surfaced. Not through the court. Through a property rights advocacy group in Nashville called the East Side Land Trust. Someone had sent them a copy, no name, no note, with a list of addresses attached. 12 properties. 12 quiet title actions, 12 sets of families who had never been served. The Land Trust's director called a press conference on a Thursday morning. She had a lawyer beside her, and a stack of deeds, and a calm, precise manner of speaking that reporters had learned not to interrupt. By noon, 2 local news stations had picked up the story. By evening, Carter Whitfield had issued a statement calling the claims premature and mischaracterized. His photo ran next to the word premature, and the internet noted the irony without being asked. By the following morning, Miriam's phone had rung 4 times. 3 of the families on that list had found her number. She didn't know how. She answered anyway. I can't represent all of you, she told them honestly. But I can help you find people who can. And I'll help coordinate. That I can do. She made coffee. She got out a legal pad. She started writing names. The settlement that came 2 weeks later was not a dramatic courtroom moment. There was no gavel. There was no gallery of people watching. There was a conference table. Different building, neutral ground. A mediator named Sandra Osei, who wore purple glasses and did not tolerate nonsense. And there were lawyers for both sides and a document that took 4 hours to finalize. Marcus received clear title to the property at 1418 Shelby Avenue. He received the full cost of the transaction back, plus 2 years of carrying costs, plus a sum for emotional distress that Miriam had negotiated in the last hour when Carter was tired and wanted to go home. Whitfield Property Solutions agreed to an independent audit of all 12 properties. An ombudsman, agreed upon by both parties, would oversee it. Any family found to have a legitimate claim would receive the same offer Marcus had received. Carter signed without looking at Miriam. His father, who had sat in the back of the room without speaking for most of the afternoon, stood when it was done and walked to the door. He paused. He looked at Miriam. He didn't say anything. She didn't expect him to. She gathered her papers and went home. Marcus had dinner ready when she got there. He had made the chicken the way she'd taught him, simple, just the right amount of garlic, don't rush the pan. He'd set the table with the good placemats, the ones she only brought out for Sundays. She sat down. He sat across from her. He didn't say anything for a moment. How did you do that? He finally asked. Miriam looked at the chicken. She picked up her fork. The same way I always did, she said. He watched her. I didn't know, he said. I mean, I knew you were a lawyer, but I didn't know. I didn't understand what that meant. People rarely do, she said. Until they need to. They ate. The magnolia scraped the window the way it always did in the wind. The kitchen was warm. Outside, 3 blocks away, a lot on Shelby Avenue sat with a cleared title and a boy's savings in the ground and the beginning of something that hadn't been built yet. Marcus broke ground in the spring. He hired a contractor, a woman named Dolores from the neighborhood who'd been doing renovation work on the east side for 15 years. He showed her the drawings he'd made, the careful precise lines, the duplex with the deep front porch and the 2 mailboxes and the mature tree he'd planned to keep along the north fence. Dolores looked at the drawings for a long time. You do these yourself? She asked. Yeah, Marcus said. Good, she said. We'll use them. Miriam came by on the first Saturday of the build. She stood at the edge of the lot and watched them mark the foundation. She had her coffee and her orthopedic shoes, and she did not say very much. She just watched. The Land Trust had published a report by then. All 12 families. 7 of them had reached settlements. 3 more were in mediation. 2 were preparing to go to court, with attorneys who had volunteered after the story broke. The audit was ongoing. The state legislature had begun discussing a change to the notice requirements for quiet title actions, a small amendment, buried in a larger bill, but real. Constance called from Denver on a Sunday. She had seen the news coverage. Someone had posted a clip from the press conference. Not Miriam. She hadn't been at the press conference. But Sandra Osei had mentioned her by name, the attorney who first brought the title chain discrepancy forward, and someone in the comments section had figured out who she was. Mama, Constance said, people are asking about you. I know, Miriam said. What are you going to do? Miriam looked out the window at the magnolia. Edmund had planted it 30-some years ago. Now it was taller than the house. I'm going to finish my coffee, she said. There was a pause. Mama, Constance said. Be serious. I am being serious, Miriam said. The coffee is getting cold. The cedar box sat on the closet shelf. The bar card was no longer inside it. It was in Miriam's wallet, where it had lived for 30 years before she put it away. It fit exactly where it always had. She wasn't taking new clients. She told people that clearly. She was 64 and her knee hurt, and she had a garden to tend, and 2 books to read every week, and biscuits to make on Sunday for whoever showed up. But she had joined the Land Trust's legal advisory committee. 2 hours, every other Thursday. She reviewed documents. She told the young attorneys things they hadn't thought to look for. She taught the way her own mentor had taught her, without condescension, without impatience, with the kind of attention that says your question matters, and so do you. On a Thursday in early June, a woman in her 50s came into the committee meeting late, out of breath, with a folder of documents, and the look of someone who had been up since 4 a.m. Her name was Renata, something. Miriam forgot the last name immediately. And her family's property had been on that list, and she had just received a letter that didn't make sense, and she needed someone to look at it. Everyone at the table turned toward her. A few reached for the papers. Miriam was already reading. The room watched her. The young attorney beside her watched her hands as she moved through the pages, the quick, precise movement of someone who knew exactly what she was looking for and where it would be. "Here," Miriam said. She pointed to a line at the bottom of page 3. Renata leaned in. "What does that mean?" Renata asked. Miriam told her, clearly, without jargon, without the voice people sometimes use to make simple things sound complicated, so that only they can explain them. When she was done, Renata sat back in her chair and let out a breath she'd clearly been holding for days. "So it's fixable?" she asked. "It's fixable," Miriam said. "There are people the world looks at and decides it already knows everything worth knowing. It decides by the cardigan and the reading glasses and the shoes and the careful way they move through a room. It decides by the gray hair and the age and the particular quiet of someone who has already done the loudest parts of their life and chosen, deliberately, to live the rest of it softly. The world is wrong about these people more often than it knows. I think about what it takes to walk into a room where someone has already dismissed you. You've said a word and not flinch, not perform, not try to prove yourself. Just open your folder and begin. I think about what Miriam carried into that conference room. Not bravado, not anger. Just 30 years of knowing exactly what she was doing and the patience to let the work speak for itself. The patience that only comes from having done something long enough that you don't need anyone to believe in it. You already know. Her grandson is building something 3 blocks from the house where she still makes biscuits. On Sunday mornings, the foundation is poured. The walls are going up. There's a tree along the north fence that they kept, like the plans said. The cedar box sits open on the closet shelf. There's nothing in it now. It has served its purpose. And somewhere in Nashville, in a room where someone has just been told they don't belong, a woman is opening a folder. Not asking permission, not waiting to be believed. Just beginning. That's all it ever was. That's all it ever took. Tell me, is there someone in your life who carried something like that? A strength nobody thought to ask about, a history nobody could see. Leave it in the comments. I read everyone. If this story moved you, share it with someone who needs to hear it today. And if you haven't already, subscribe, because this channel exists for exactly these people. The ones the world looks past. The ones who were never as small as anyone assumed. Next week, I'm bringing you a story about a custodian who shows up to a corporate board meeting and changes everything. You won't see it coming. Don't miss it.